All right, Title 40 CFR Chapter 1, July 1st, 2019, Subpart 24. Uh, Part 24, Subpart B, Hearing Orders and Requiring Investigation of Studies. Qualification Presiding Officer, Ex parte decision of the proceed with the presiding officer shall either the regional judicial officer as described in the Title 40 CFR 2204B, another attorney employed by an agency who has not been in prior connection with within the case, including for the performance of any of the investigation, prosecution, for the end, no time with the after the issuance of the initial administrative order, prior to the issuance of the final order shall be the regional administrator, the presiding officer, any of the person will abide with the official with the decision with the in the case. The discussion ex parte with the manner of the proceeding with any of the interested person outside of the agency, with the agency, with the staff member, the performer, the prosecutorial investigation function in such a proceeding, of the factually related to the proceeding, and then representative of such for the person after issuing with the initial order, prior to the issue with the final order of the regional administrator, of the presiding officer, any other person advises these official of the decision on the case of the receiver from the on the behalf of any of the party ex parte communication and information which is relevant to the decision on the case of whether the other parties have not have the opportunity to respond. Summary of such information shall not be served on all other parties who have any opportunity to reply on the same within 10 days of the service of the summary. 2410, scheduling of the hearing of the pre-hearing submission for the live respond. With the date and time of the hearing of the presiding officer established for the day of the location of the agenda for the request for the public hearing transmitted information party for the subject 2410C for the permanent hearing shall be scheduled to be held within 30 days of the agency received with the request for the public hearing. Pre-hearing submission with the respondent at any time with the open 5 business days prior to the hearing of the respondent is not required to submit with the inclusion of the administrative record of the information agreement with the supporting respondent with the position on the facts of the law with the relief of the each of the relief to the order of the question. Copy of the any information argument submitted by the respondent shall be served and such of the clerk and petitioner must be the same as at least 55 business days prior to hearing before the hearing. Postponement of the hearing of the presiding officer may grant with the extension of the time with the conduct of the hearing upon written request of either the party, but if a good cause shown with the after consideration any prejudice for the other presiding party with the presiding officer may not examine the date of which the request of the hearing is under in 2405A. Location of the hearing may be held in the city where the relevant EPA regional office is located unless presiding officer determines if there is a good cause to hold it in another location. 2411. The hearing of the oral presentation written submission of the party presiding officer conduct the hearing of the affair with one partial way of the taking action with the need of the avoid unnecessary delay with the scoop of the presenting of the material to maintain the order during the proceeding with the representative of the EPA shall be introduced with the administrator of the record prepared summary of the basis of the order of the respondent shall have the responsible opportunity to address the relevant issue present with the views of the legal counsel of the technology advised with the person presiding officer may also have the technical legal discussion interchange between the party, including the respond with the question of the extent of the deeming appropriate is not agent for the intent of they provide with the EPA respond with the opportunity to engage with the director examination cross-examination with the witness. Presiding officer may address the question respond to EPA representative during the hearing of each party shall ensure the representative of the end or president of the hearing who is and are capable of responsible for responding to the question and articulating the party's position on the law of the fact is issued with the representative with the condemnation of the throughout no fault of his own certain documents that are supportive of the position will not be submitted before the hearing in accordance with the requirements of 2410B if may submit with the document with such at the hearing otherwise new documentary supplementary may be submitted at the hearing presiding officer may upon request grant the petitioner leave to respond to the submission made by the respondent pursuant to section 2410 or 2410B. Presiding officer shall have the decision ordered either the party to submit with additional information included but not limited to the post-hearing brief, the done development, factual, technical, legal matters, whatever the deems appropriate, with either at or after the hearing. All right, 2412, summary of the hearing of the presiding officer recommendations. Assume the practical after the conclusion of the hearing of the writing of the written summary of the proceedings shall be prepared with the summary shall at minimum identify the date of the known attending of the hearing the basis for the time of the respond with the contest for the terms of the order of the summary must be assigned with the presiding officer. The presiding officer will evaluate the entire administrator of the record on basis of the review of the representative of the EPA with the respond with the hearing which shall prepare with the file recommended with the decision of the record. The administrator of the recommended with the decision must address all of the material of the issue for the fact of the law properly with the review of the respond with the must recommended that the order may be modified with withdrawn with the issue of the modification of the recommended decision must provide with the explanation for the citation or the material contained with the record for the decision to modify the term of the order for the issue for the order without change without the order to withdraw the order the recommended decision shall be based on the administrative record if the presiding officer finds that any of the successive relief provision for the order of non-support of the preponderance of the evidence in the record of the presiding officer shall recommend the order of the modified issue on the terms of the support of the record of the withdrawn. Anytime within 21 of the days of the strip of the recommended of the decision of the parties may file with a comment with the recommended decision of the clerk, but the clerk shall promptly transmit any of the comments received with him to the regional administrative of his consideration in reaching the final decision. Subpart C, hearings and orders requiring corrective measure.